Hi everyone, welcome to Lucid Mains program by Ekam IAS. Today we will deal with removal of Chief Justice of India and its related issues. Recently, there has been a move to remove Chief Justice of India from his office. Even though the move failed as the chairman of Rajya Sabha rejected the motion for removal, it is very important as this is the first time that Chief Justice of Supreme Court is facing process of removal. And also, among the 5 charges accused against him, one is very important for our exam point of view. That is, abuse of authority arbitrarily to assign cases to select judges. This we will see in detail later. So, first let us see the history of removal of judges in India. It is the 7th judge to face a motion of removal from office. But interestingly, no one has been removed so far. So, here is the list of all 6 judges who face removal proceedings. So, all these previous judges who faced removal either resigned before the process was completed or their removal failed to receive parliament sanction. And in the current case, chairman rejected the motion for removal in the Rajya Sabha. That is, from the very beginning itself, it is failed. Next is the ground for removal. A judge can be removed from the office on the basis of proved misbehavior or incapacity. Actually, the constitution does not define proved misbehavior. So now we have the Judges Enquiry Bill 2006 and the Judicial Standards and Accountability Bill 2010 along with Supreme Court's judgment, based on which we are now deciding whether it is a case of proved misbehavior or not. And now let us see what the constitution says about the removal of judges. Article 124 and Article 218 deal with removal of Supreme Court and High Court judges respectively. So, a judge from a Supreme Court or High Court can be removed from his office by a presidential order after an address by each House of Parliament supported by special majority. A special majority means majority of the total membership of the House and majority of not less than 2/3 of the members of the House present as well as voting. Here again, the procedure for removal is not given in the Constitution. But we have Judges Enquiry Act 1968 which outlines the procedure for removal of judges. So first, we need to introduce the motion. This can be introduced either in the Lok Sabha or in the Rajya Sabha. If it is in the Lok Sabha, it must be signed by 100 members and will be given to Speaker. If it is in the Rajya Sabha, it must be signed by 50 members and should be given to Chairman of Rajya Sabha. So the Speaker or Chairman may admit or refuse to admit the motion. If it is admitted by Chairman or Speaker, they will constitute a committee to investigate into the charges. And this constituted committee will consist of 3 members. They are Chief Justice or Judge of the Supreme Court, and second one is Chief Justice of High Court, and third one is a distinguished jurist. If the committee find this judges guilty, the House can move ahead with the motion. In both House, it must be passed by special majority and then it is presented before the President, and finally, President pass an order to remove the judge. So, this is the procedure for removal of a judge. So, next let us see the issues involved in this case. So, first one is Chairman's power in rejecting the motion. Here the debate is about the decision of Chairman to refuse to admit the motion. As now, the Chairman rejected the motion saying that misbehavior has not been proved and there is only little merit in the charges. But actually, Supreme Court has already ruled that Chairman is not bound to admit the motion moved in the House. So, what he did is okay. But the question here is, what is next? Can they go for a judicial review against the decision of Chairman? So, that is the next issue. That is, the judicial review on Chairman's decision. In Subcommittee of Judicial Accountability case, it is noted that the entire process from admission of a motion until conclusion of an inquiry by the committee is governed by the Act, hence subjected to judicial review. And parliamentary process will start only after the committee makes a finding, from which it is excluded from the judicial review. So, hope it is clear that it is possible for a judicial review against Chairman's decision. So, next is about the punishment in case of lesser offence. Actually, severity of wrongdoing varies and removal of judges only suitable for grave wrongs. So, what about the lesser offence? Unfortunately, there is no guidelines about this matter now and hence remains as an important issue. And next let us see about the need for revisal of judges removal process. Here, we have seen that there has been many judicial impropriety, but no one has been removed so far. And this process is too elaborate and time consuming. More than that, it says that the process goes against the natural justice, as the chance of guilty judge getting removed from the office depend on political process like voting, as at final stage, they need a majority vote for removal. On the other hand, if it is revised, sometimes it may affect the independence of judiciary. So, this is also an important issue. So next is about the CJI's power in allocating cases. This we need to look in detail, and as this is significant as there has been an unprecedented press conference by 4 senior most judges raising this issue, and there has been a PIL filed in the court seeking a mechanism to allocate cases by Supreme Court. In this PIL, Supreme Court ruled that the power has been given to judges to protect the constitution and democracy, and the listing of cases was the discretion of CJI, who is the master of roster. In short, we can say that the authority of CJI to allocate case comes from constitution. So now let us see the points which is in favor of allocating cases by CJI. CJI is considered as the first among the equal, hence has the authority to decide allocation of cases and setting up of benches. Since the CJI is high constitutional functionary, there cannot be any distrust about the responsibility he discharges. And another thing is, the number of cases filed in Supreme Court on daily basis is high. So it will not be feasible to have a collegium and making them to sit twice or thrice in a week, as already there is a high backlog of cases in Supreme Court. So next is about the points against allocating cases by CJI. It says that the convention of recognizing CJI as the master roster and assigning cases to different bench is for discipline and efficient transaction, and it is not a recognition of superior authority. Another point against allocation by CJI is that as there is no procedure for allocation, there is a chance of exercising power arbitrarily, which will go against right to equality. It is also says that there were instances where sensitive cases were allocated to particular bench in contrast to the rules. So that's all about the point against allocation by CJI. So next is the way forward. We already discussed about the issue of lack of guidelines for lesser offences. So here 195th report of Law Commission in the context of Judges Enquiry Bill 2006 suggested some minor measures to discipline lesser violations like issuing advisories, temporary withdrawal from judicial work and requesting retirement, etc. So, till a new law comes in, we can use this. Next is about the bench fixing or allocation of cases. Actually, since mid-1990s, there has been a software which helped to pair up the cases with regular bench, that is 2-judge bench. So, similar technology can be used to allocate cases for larger bench also. And in very sensitive cases, we can think about a collegium for allocating cases, as it will give less room for arbitrariness. Then, if the rule of CJI being master roster is used in an arbitrary manner, violating the right to equality, rules can be struck down. As in Premchand Garg case, Supreme Court ruled that rules by the court violative of fundamental right can be struck down if it goes against the constitution. Here, the right to equality is a fundamental right, so it can be struck down. Next is about the transparency. Court must be transparent enough to keep the trust of public in judiciary. And as per the Judges Enquiry Bill 2006, create a mechanism where any person can complain about the misbehavior of Supreme Court or High Court judges. And then establish a permanent body like National Judicial Commission to enquire such allegations. Here, the judges was going against judges in public, which cannot be considered as a good precedence. So, this kind of leadership crisis must be solved within the system by giving ample space to fellow judges and listening to their problem. So, this is about the way forward. That's all about the topic. Thank you.